I'm Daniel Sterling, and I've been practicing probate, family, and fraud law in Texas for over 15 years. My days are usually a whirlwind of court filings, client meetings, and the occasional battle royale in the courtroom. But every so often, a case lands on my desk that reminds me why I became a lawyer in the first place. A case so brazen, so filled with betrayal, that it transcends mere legal dispute and delves deep into the darker corners of human nature. I still remember the day Marcus Thorne walked into my office. He was a man in his mid-40s, an architect by trade, usually known for his calm demeanor and meticulous planning. But when I saw him, he was a ghost, pale, and visibly shaking, clutching a sheaf of papers like a lifeline. He sat opposite me, his eyes wide with a mixture of grief and disbelief, and began to tell me a story that made my blood run cold. His father, Arthur Thorne, a beloved and prosperous rancher, had passed away suddenly from a heart attack just weeks prior. Arthur had a substantial estate, built over decades, and a clear, well-established will that left everything to his 3 children, including Marcus. Or so they thought. The shocking detail that immediately grabbed me, the detail that sent a jolt through my entire professional being, was this. Not only had a new completely different will surfaced dated just 2 months before Arthur's death, but the sole executor named in that will was Arthur's ex-wife, Brenda Davies, a woman he had divorced 5 years ago after a bitter, protracted legal battle. And as if that wasn't enough to make your jaw drop, this new will also drastically reduced the children's inheritance, leaving the bulk of the estate to Brenda. Marcus looked at me, his voice barely a whisper, and said, "Mr. Sterling, she's already started selling off my father's horses. She's changing the locks on the ranch house. It's like she's erasing him, erasing us. What can we do?" My father would never have wanted this. What was at stake? Millions of dollars, yes. The sprawling Thorne Ranch, valuable livestock, extensive investment portfolios. But more than that, it was Arthur Thorne's legacy. It was the inheritance he had carefully planned for his children, now under the control of a woman who had, by all accounts, caused him immense pain. It was the emotional integrity of a family ripped apart, fighting not just for money, but for their father's true last wishes. This wasn't just a probate case. It was a battle against audacious greed and a profound betrayal of trust. Here's what you need to understand about the legal landscape surrounding a case like this, particularly here in Texas. When someone passes away, their estate goes through a process called probate, where a court validates the will, if there is one, identifies the assets, pays off debts, and distributes what's left to the beneficiaries. The person appointed to oversee this entire process is called the executor. It's a role of immense responsibility, trust, and, most critically, fiduciary duty. Under the Texas Estates Code, Paragraph 351, Rule 1, an executor is considered a fiduciary. This means they are legally obligated to act with the utmost honesty, loyalty, and good faith, solely in the best interests of the estate and its beneficiaries. They can't self-deal, they can't favor themselves over others, and they certainly can't mismanage or embezzle funds. It's a sacred trust. Now, what if that executor isn't living up to that trust? That's where Texas Estates Code, Core 404, No. 3 comes into play, specifically outlining the grounds for removing an executor. A court can remove an executor if they are found to be incapable of performing the duties of the office, have engaged in gross misconduct or gross mismanagement, have embezzled or tried to embezzle, or have a material conflict of interest that makes them unsuitable. In our case, having an ex-spouse as an executor, especially one who also stands to gain significantly from a freshly signed, questionable will, creates an immediate and glaring conflict of interest. It's a giant red flag, waving furiously. Beyond executor removal, we also had to consider challenging the will itself. This typically involves proving that the deceased, Arthur, lacked testamentary capacity, meaning he wasn't of sound mind when he signed the new will, or that he was under undue influence, meaning someone like Brenda coerced or manipulated him into signing it against his true wishes. These were the legal frameworks we would be operating within and understanding them was key to unlocking justice for Marcus and his family. The law, in its essence, is designed to protect people from this exact kind of exploitation. Marcus Thorne was, as I mentioned, an architect, a man who built things from solid foundations. His father Arthur had been the same, a bedrock of the community, known for his integrity and his prize-winning Longhorn cattle. Arthur was in his early 70s when he passed. 5 years prior, he'd gone through a brutal divorce from Brenda Davies, his second wife. Brenda, in her early 60s, was a sharp-tongued woman with an insatiable appetite for the finer things in life, and the divorce had been notoriously ugly, primarily because she'd tried to bleed Arthur dry. Arthur, heartbroken but resolute, had eventually settled, making it clear to his children that Brenda was out of his life for good, both personally and financially. After the divorce, Arthur updated his will, leaving his entire estate, valued at roughly $8 million, to his 3 children, Marcus, his sister Sarah, and his brother David. This was his clear stated intention for years. Then, about a year before his death, Arthur began to show subtle signs of cognitive decline. He'd forget things, repeat stories, and sometimes seemed a little confused. Nothing alarming enough for a formal dementia diagnosis, but noticeable to his children. Marcus, living closest to his father's ranch, outside Austin, would visit frequently, helping with bills and appointments. The timeline of events leading to my office was chillingly precise. 5 years ago, Arthur and Brenda's acrimonious divorce finalized. Arthur updated his will, leaving everything to his children. 1 year ago, Marcus and his siblings first noticed Arthur's cognitive slips. 6 months ago, Brenda Davies, seemingly out of nowhere, began calling Arthur more frequently. Marcus noticed her name popping up on his father's caller ID again. 3 months ago, Brenda started visiting the ranch, ostensibly to check on Arthur. She claimed she was just being neighborly, despite living an hour away. Marcus found it unsettling. 2 months ago, January 15th, the date on the new will, which named Brenda as sole executor and a primary beneficiary, drastically reducing the children's share. Marcus learned later that a small-town attorney, Mr. Jenkins, known for his quick turnaround on estate documents, drafted it. 1 month ago, March 2nd, Arthur Thorne suffered a sudden, fatal heart attack. Immediately after Arthur's death, Brenda, armed with the new will, swiftly moved to probate it, froze the children out, and began liquidating assets. Weeks later, March 25th, Marcus, numb with grief and battling a gnawing suspicion, walked into my office. Marcus was beyond emotional. He felt like his father had been stolen from him twice, first by death, and then by this audacious act of manipulation. He couldn't reconcile the loving father who'd spent his life building a legacy for his family with a man who would leave everything to an ex-wife he despised. His vulnerability was palpable. "She's already taken so much," he choked out. "The ranch has been in our family for generations. He would never have done this, Mr. Sterling. He just wouldn't." His desperation convinced me this wasn't just a legal fight. It was a moral imperative. This was a man fighting to protect his father's memory and ensure justice prevailed. Our investigation started immediately. The first thing I did was file a formal notice of appearance with the probate court, putting Brenda and her attorney, a notoriously aggressive and ethically flexible lawyer named Brad Harrison, on notice that we were contesting the will and demanding a full accounting of the estate. I also sought an emergency temporary restraining order to prevent Brenda from liquidating any more assets or making any further distributions from the estate. Harrison, as expected, fought it tooth and nail, claiming Marcus was simply a disgruntled heir, making frivolous claims. But the judge, after hearing our initial outline, granted a limited order, pausing asset sales pending further review. It was a small victory, but it bought us time. My team and I then dove deep into the detective work. I hired a forensic accountant, Sarah Chen, a no-nonsense number cruncher with a reputation for sniffing out financial irregularities. I also brought in Dr. Eleanor Vance, a respected geriatric psychiatrist, to review Arthur's medical records and provide an expert opinion on his cognitive state in the months leading up to his death. Our first area of focus was Arthur's finances. Sarah meticulously combed through bank statements, investment portfolios, and credit card records for the past 18 months. What she found was startling. In the 3 months leading up to Arthur's death, there were numerous large, unexplained withdrawals and transfers from his primary accounts, totaling over $500,000. These transactions were highly unusual for Arthur, who was typically conservative with his finances. Furthermore, several of these payments seemed to route through intermediary accounts before disappearing. This immediately raised a red flag. Meanwhile, Dr. Vance's review of Arthur's medical files revealed several physician's notes from the last year mentioning mild cognitive impairment, occasional confusion, and short-term memory deficits. While not a formal dementia diagnosis, it strongly supported our theory that Arthur was vulnerable to undue influence around the time the new will was signed. It wasn't just anecdotal. There was documented medical evidence. I also pressed Marcus for any digital breadcrumbs. He remembered his father used an old tablet for emails and light browsing. We managed to retrieve some archived emails. And there they were, a series of emails from Brenda to Arthur, dating back almost a year, slowly and subtly re-establishing contact. Initially, they were checking in, then concerned neighbor, then let me help you with your bills. They painted a picture of calculated infiltration and isolation. One particularly damning email from Brenda to Arthur read, "Your children are so busy with their own lives, Arthur. They don't understand your needs like I do. Perhaps it's time you thought about who truly cares for you when it matters most." This was manipulation, plain as day. Marcus also recalled his father mentioning feeling pressured by Brenda to sort out his affairs, and sometimes complaining that she was always around. Our investigation hit a temporary dead end with Mr. Jenkins, the attorney who drafted the new will. He stonewalled us, claiming attorney-client privilege and refusing to provide details about the circumstances under which Arthur signed the will, beyond a perfunctory statement that Arthur appeared of sound mind. His evasiveness only fueled my suspicions. Harrison, Brenda's lawyer, continued his aggressive tactics, pushing for quick depositions and trying to portray Marcus as ungrateful and opportunistic. He scoffed at our unsubstantiated claims of undue influence. But I wasn't deterred. I knew we were on the right track. My strategic thinking was clear. Prove financial fraud and breach of fiduciary duty first, and the will contest would become secondary or even unnecessary for removing Brenda. Then came the breakthrough moment, the discovery that shifted the entire tectonic plate of the case. Sarah Chen, my forensic accountant, called me late one Tuesday evening, her voice buzzing with excitement. "Daniel," she said, "you're not going to believe this. I followed the trail of those mysterious $500,000 withdrawals." My heart pounded as she explained. A significant portion of that money, specifically $250,000, had been funneled through several domestic accounts before being wired out of the country. Sarah had managed to get an international subpoena through the proper channels, and the destination was an offshore account in the Cayman Islands. It was disguised under the name of a shell corporation, Island Breeze Holdings. But Sarah, with her tenacious financial sleuthing, managed to pierce through the corporate veil. The ultimate beneficial owner listed for Island Breeze Holdings was none other than Brenda Davies, using her maiden name, Brenda Miller, for an extra layer of obfuscation. "It wasn't just mismanagement, Daniel," Sarah explained. "It was outright embezzlement. She set this up weeks before Arthur died, while she was actively insinuating herself back into his life and simultaneously pushing for that new will. This wasn't a gift. It was theft, plain and simple." My stomach dropped, then immediately tightened with fierce resolve. This was it. This wasn't just circumstantial evidence of undue influence or a mere conflict of interest. This was the smoking gun, irrefutable proof of a calculated, premeditated scheme to defraud Arthur Thorne and his estate. It demonstrated a clear pattern of financial exploitation and a profound breach of any reasonable expectation of trust, let alone fiduciary duty. Legally, this evidence was devastating. It not only provided grounds for immediate removal of Brenda as executor under Texas Estates Code, Probate 404, Euro 3 for embezzlement and gross misconduct, but it also painted a clear picture of her predatory intent, making the undue influence argument for invalidating the new will far stronger. She wasn't just subtly coercing him, she was actively stealing from him while preparing to claim his entire estate. I called Marcus immediately. His initial reaction was silence, a heavy, disbelieving quiet on the other end of the line. Then I heard a choked sob. "She actually stole from him," he whispered, his voice thick with emotion. Even then, when he was vulnerable, when he trusted her, she just took. The confirmation of Brenda's treachery, though painful, brought a new level of clarity and resolve to Marcus. His grief was now tempered by a fierce determination for justice. "We have to stop her, Daniel. We have to make her pay." I assured him we would. This was no longer just about the will. It was about exposing a predator. The air in the probate court of Travis County was thick with tension on the day of our hearing for Brenda's removal as executor. Judge Elena Rodriguez, a no-nonsense jurist known for her sharp intellect and even sharper wit, sat on the bench, her gaze piercing. Brenda Davies sat stiffly at the opposing counsel table, her usual smug expression replaced by a nervous frown, flanked by Brad Harrison, who looked unusually subdued. Marcus, beside me, was pale but composed, his resolve hardened by the recent revelations. My strategy was straightforward. Present the overwhelming evidence of Brenda's financial malfeasance and conflict of interest to compel the judge to remove her immediately from her executor duties, effectively freezing her ability to touch another dime of Arthur's estate. I began by calling Marcus Thorne to the stand. He testified eloquently about his father's declining health, Brenda's sudden reappearance in their lives, and the stark contrast between Arthur's previous, well-documented wishes and the abrupt, inexplicable change reflected in the new will. Harrison's cross-examination tried to paint Marcus as a disgruntled son, fabricating stories due to greed, but Marcus held firm, his emotional sincerity undeniable. Next, I called Sarah Chen, our forensic accountant. She was a picture of calm professionalism. With clear charts and annotated bank statements, she methodically laid out the financial trail. She detailed the unusual withdrawals, the shell corporation, and the final destination of the $250,000 in the offshore account under Brenda Davies' maiden name. She explained, in plain language, how these transactions were not just suspicious, but clearly indicative of a deliberate attempt to siphon funds from Arthur Thorne while he was at his most vulnerable. Harrison tried to discredit her methodology, questioning the validity of the international subpoenas and implying she was merely doing my bidding. But Sarah was unflappable, her facts solid, her numbers undeniable. She patiently explained the layers of financial obfuscation and how she had painstakingly peeled each one back. Then came my opportunity to cross-examine Brenda Davies. This was the moment I had prepared for, the climax of our initial assault. Brenda took the stand, her eyes flitting nervously around the courtroom. "Ms. Davies," I began, my voice even, "you testified earlier that you had no significant financial dealings with Mr. Thorne in the months leading to his passing, beyond assisting him with routine household bills, correct?" She puffed out her chest slightly, trying to regain her composure. "Yes, absolutely. Arthur was a very private man." "And I respected that." Her eyes flickered towards Harrison, seeking reassurance. "And you also claim that Arthur Thorne, of his own free will and sound mind, chose to name you his sole executor and substantially increase your inheritance, reducing his children's share, in a will dated January 15th, just 2 months before his death?" "That is correct," she stated confidently, her chin lifting slightly. "He trusted me. He knew I would honor his wishes." "I see," I said, a slight pause for dramatic effect. "Then I direct your attention to Exhibit 47, I said, as the court clerk projected the wire transfer documents and the beneficial ownership details of Island Breeze Holdings onto the screen. "Is this your maiden name, Brenda Miller, listed here as the ultimate beneficial owner of this offshore account?" Brenda's face, which had been pale, visibly drained of all color. She stared at the screen, then at me, then back at the screen, as if seeing a ghost. I don't know what that is," she stammered, her voice suddenly thin. "You don't know what it is?" I pressed, stepping closer to the witness stand. "This account, which received $250,000 from Arthur Thorne's personal investment account just weeks before his death, after the will naming you as executor was signed. You claim no knowledge of this entity, Island Breeze Holdings, or its ultimate beneficiary, Brenda Miller, which is your maiden name." "No, Arthur must have done it himself." Her voice rose, cracking with desperation. "He sometimes did things for tax purposes, complicated investments." Despite his known cognitive impairment, and just weeks after you claim he willingly named you executor and reduced his children's inheritance? I hit her with the full force of her lie. You expect this court to believe Arthur Thorne, in his fragile state, secretly set up an offshore account under your maiden name and transferred hundreds of thousands of dollars to it, all while telling his children his finances were under control and he was leaving everything to them. Harrison jumped up. "Objection, Your Honor. Argumentative. Counsel is badgering the witness." Judge Rodriguez, who had been watching Brenda intently, her pen still, raised a hand. Sustained. "But counsel, I think you've made your point." She then turned her steely gaze to Brenda. "Ms. Davies, you will answer the question about your specific knowledge of these transfers and your connection to this offshore account. Your previous testimony was that you had no significant financial dealings." Brenda stammered, contradicted herself, digging herself deeper into the hole. Her facade crumbled. Finally, under the undeniable weight of the evidence and the judge's unwavering stare, she broke down, admitting she had helped Arthur with some investments he wanted to keep private from his children. It was a feeble, transparent lie, but it was an admission nonetheless. Harrison, beside her, looked utterly defeated. His shoulders slumped. The courtroom went silent, the gravity of the revelation hanging heavy in the air. Judge Rodriguez, her face unreadable, took a long, deliberate breath. Her gaze swept from Brenda, now openly weeping on the stand, to Harrison, whose face was a mask of professional despair, then to me, and finally to Marcus, whose eyes were fixed on the judge, trembling with anticipation. "The court has heard compelling evidence today," Judge Rodriguez began, her voice clear and resonant. "Ms. Davies, your testimony regarding your financial involvement with the deceased, Mr. Arthur Thorne, is not only deeply troubling, but directly contradicted by the meticulous financial evidence presented by the petitioner." She paused, her eyes narrowing. "Your actions, both leading up to Mr. Thorne's passing and in the weeks following, demonstrate a clear and ongoing pattern of self-dealing, a profound lack of transparency, and a blatant breach of the fiduciary duty expected of an executor, even one yet to be formally confirmed by this court." She looked directly at Brenda. "Effective immediately, Brenda Davies is hereby removed as executor of the estate of Arthur Thorne. The court finds clear and convincing evidence that her continued service would constitute gross mismanagement, present an insurmountable conflict of interest, and amounts to, in the court's estimation, an intent to embezzle." Brenda gasped, a guttural sound of shock and defeat. Harrison slowly sank back into his chair. His shoulders slumped. Judge Rodriguez continued, her voice gaining authority. "Furthermore, the court will appoint a neutral, independent administrator, Ms. Evelyn Hayes, a seasoned probate attorney, to immediately oversee the entirety of the estate. Ms. Hayes will conduct a full and comprehensive accounting of all assets, liabilities, and transactions, with particular scrutiny to all funds transferred in the past 2 years. And finally, given the nature and severity of the financial irregularities uncovered, I am referring this matter to the District Attorney's Office for immediate review and potential criminal investigation into fraud and elder exploitation." The gavel came down with a resounding thud. Marcus, sitting beside me, let out a shaky breath, tears streaming freely down his face. He didn't say a word, just gripped my arm, his eyes silently conveying a mix of overwhelming relief, vindication, and a deep, profound gratitude. The initial battle was won. Justice for his father, for his family, had been served. Brenda Davies, the predatory ex-spouse, was not only stripped of her ill-gotten power, but was now facing the full weight of criminal prosecution. It was a victory, hard-fought and undeniably earned. In the months that followed, the independent administrator, Ms. Hayes, meticulously unwound Brenda's financial machinations. The $250,000 in the offshore account was eventually recovered and returned to the estate. The fraudulent will, now devoid of its key proponent, was subsequently invalidated, and Arthur's true will, leaving everything to his children, was finally probated. Brenda was indeed charged by the district attorney's office with multiple counts of fraud and elder abuse. The civil case for recovery of additional funds was also easier to pursue after the judge's criminal referral and the weight of the evidence. Here's what I learned from this case, something that has been reinforced repeatedly throughout my career. Never underestimate an opponent's greed, but also never underestimate the power of meticulous investigation and unwavering legal strategy. Fiduciary duty isn't just a dry legal term. It's a sacred trust, and when that trust is violated, the courts, with enough compelling evidence, will act decisively. The broader legal lesson for anyone watching is this. If you have an estate plan, make sure it's current, clear, and known to your trusted loved ones. But even more importantly, be vigilant. Watch for the warning signs of financial exploitation, especially involving elderly or infirm individuals. Sudden unexplained changes to a will or power of attorney are huge or red flags. An ex-spouse or estranged relative suddenly re-entering the picture, isolating the vulnerable individual, or claiming to help with finances are all critical indicators that something nefarious might be happening. Unexplained financial transactions, missing funds, or new joint accounts should trigger alarm bells. My practical advice is this. If you're facing a situation like Marcus, don't hesitate. Time is of the essence. Assets can disappear quickly. Seek legal counsel immediately. Document everything. Don't let perceived cost deter you. Because the cost of inaction, the cost of losing an entire inheritance, or seeing a loved one's legacy destroyed, can be far, far greater. This case was a stark reminder of human desperation, how far some people will go for money, and the lengths we must go to protect those who cannot protect themselves. Months later, Marcus and his siblings are slowly but surely rebuilding their lives and their father's legacy. The Thorn Ranch is now firmly in their hands, just as Arthur had always intended. The horses are back, and the family is healing. Brenda Davies is awaiting trial, facing the full consequences of her actions. Justice, while sometimes slow and arduous, can prevail. This is why I do what I do, to protect the vulnerable, to fight for justice, and to make sure legacies are honored, not stolen by the greedy. Drop your questions or share your own experiences in the comments below. I read every single one. And if you think this was dramatic, you haven't heard anything yet. I've got plenty more stories to tell, so make sure you hit that subscribe button and turn on notifications so you don't miss the next one.